All right, we are live. We have my favorite guest and fan favorite, Zach Morgan. How you doing?
I'm good, Aaron, and good early happy Thanksgiving to all of the viewers.
That's right. And standing in at 6'7" and weighing in at 300 pounds, he is the Jack Reacher of Oklahoma. Oklahoma's where you live, right?
It is. I've sort of
Okay.
lived all over the country. I've done a lot of my life. I flew airplanes for a living. Lived in Denver, practiced law for a while, and now settled back to where I came from. That's sort of where I fit best in the world, I think.
So you have a pilot's license.
I do. So my bachelor's degree is in aviation. Flew for a living for a while. Went to grad school, got a master's degree. Got bored flying a desk. Went to law school. Got paid way too much money for very little emotional satisfaction suing insurance companies. And now my full-time profession is teaching student pilots. I work in academia as a faculty member, and I teach professional pilot students to prepare them for their careers out in the airlines.
Oh, wow. That's incredible. I think people assume that you were a law professor or something.
Not an unreasonable assumption, but not the direction life took me.
Very cool. Well, we're here to talk about Danny Maasterson, the hung jury, the prospects of a mistrial, what that means for both sides. You and I haven't actually had any offline chat about this, other than the fact that we wanted to talk about it. What are your
Sure.
thoughts right up front?
So, not terribly surprised. And it looks like some of the hunches some of the reporters had got were maybe fairly accurate as it pertains to, uh, there were some jurors. I think one of the sources who sent you the description of the jury breakdown sounds like it was fairly accurate. Some leaning towards guilty, some leaning towards acquittal, and then some in the middle. And I think the battle is probably not really those in the middle. It's going to be either the battle to get the not guilty to the guilty side, or the guilties to the not guilty side, depending on what the layout of the jury is.
Yeah. So, what can you tell me about Philip Cohen being very happy at the prospects of a mistrial, but Danny and his wife perhaps not so much?
So, of course, the prosecutor, if the judge does ultimately declare a mistrial, the judge has prosecutorial discretion on whether to retry the case. As it sits now, we don't know whether it's 11-1, 6-6, 7-5. We don't know the split of the jury.
Did
If
you
it
say
is
the
declared,
judge has discretion or the prosecutor?
the judge. So if the judge declares a mistrial, it then is the prosecutor's job to determine whether or not to retry the case. That determination can't be made, of course, until after the mistrial is declared, because then at that point, they will know what the split of the jury was. And if the split of the jury was 10-2, maybe 8-4 towards guilty, that's absolutely a case you retry. If it was like 8-4 not guilty, 10-2 not guilty, 11-1 not guilty, probably don't want to touch it. Because ultimately, prosecutors and ultimately their boss, the elected official, they're elected based on conviction rate. If I'm running as a prosecutor, my banner line is, "Look how many people I've successfully prosecuted and put in prison." I mean, that's the job, and so they're not going to try a case they can't win. And so, of course, the Masterson family wants a not guilty verdict. Danny and his wife and their respective families want not guilty verdicts, and so the prospect of a hung jury and the possibility of having to retry this, exhausting. Okay, just but if you're Philip Cohen, going in with the evidence that you had against you, a mistrial is almost like a draw. As my neighbors in Arkansas would say, it's sort of like kissing your sister. Nobody wins, nobody loses. In fact, everybody loses, because there's no ultimate outcome. So we have to try it again. If you're the defense attorney, that's a win, because now if you have to try it again, you know exactly what the prosecution's going to argue. You know how they're going to argue it, and you know how the witnesses are going to present. So both sides have seen everything.
I thought the same thing about the prosecutor, that maybe he would be able to change his strategy because he's seen everything the defense has to offer, which really was not much. I mean, they weren't bringing anything themselves to the table other than trying to poke holes in the arguments, right? So I guess
Sure.
my question to you here would be, who has a greater advantage in a retrial, the prosecution or the defense?
That's a fair question. I don't know. I don't know that there's a hard and fast rule. I would think in this position it would actually be the defense, because I think from the prosecution's perspective, there's going to be things that are different. They probably, let's assume for the sake of discussion that Jane Doe 4's testimony was not as helpful as perhaps the prosecution thought it might be. Prosecution doesn't have to call Jane Doe 4. The defense can. They're certainly not going to. I don't suspect the defense's strategy changes. I think they call 0 witnesses. Danny doesn't testify. They cross-examine everybody, and then they argue the state didn't prove it, which is sort of the argument they made the first time around. So I don't know that any particular side has a distinct advantage on a retrial. But I would certainly say that the defense has if there is an advantage to be gained by a retrial, at this point, it would be the defense.
Interesting. Because I was thinking, there's certain pieces of evidence that we did not see. I don't know why. Maybe you can help me understand. You've explained in some of our earlier interviews that, like, for example, a police report is hearsay. So that's not evidence.
Right.
I wonder if the same would apply to these internal Scientology reports that Scientologists write on each other. So
no. So those would not be hearsay.
So I was shocked that we didn't see those reports in this trial.
Here's the problem. Any document, let's assume the document's not hearsay, so it's otherwise admissible. I can't just hand the document to the judge or the jury and say, I want to admit this as Exhibit 1. The rules of evidence state that I have to call a witness to testify as to the authenticity of those documents, and whether it's the person who wrote it down, who physically wrote the report on paper, or the custodian of records. It's called the business records exception to the hearsay rule. Both of those individuals, let's assume that both of those individuals are either one and the same or two different people, but they're both still active Scientologists. The state could subpoena them to testify, but I'd bet all the money in my pockets against all the money in your pockets that they would go to jail on a contempt charge before they would sit in the box and say a word.
In this case, what would a custodian of records be?
The person who's designated by the company, or in this case, the entity, whichever of the Church of Scientology entities is in charge of gathering and storing that information. I'm not terribly familiar with the hierarchical structure, but whichever of this Church of Scientology entities is in charge of maintaining those records, the entity would have to disclose the person who is the custodian of that. And then that person would then be subpoenaed to testify.
Okay, and the purpose of that testimony would be to testify as to the authenticity of the document, not the truth of the information within it.
Exactly, and that's the reason we're admitting it. We're not admitting it because the information in it is true. We're admitting it to show that the report of these allegations of wrongdoing had previously been reported to members in positions of authority within the Church of Scientology.
Right. So, for example, Jane Doe 1's mother wrote an extensive series of reports, at least one report, I believe, directly to David Miscavige and other senior executives in Scientology. And I remember Jane Doe 1's mother. Well, actually, now that I sit here, I know she was going to be called to testify. As I sit here right now, I didn't refresh my memory before our chat. I can't remember if she testified. If she did, it was very briefly.
I'm not sure that she did. I don't remember seeing any notes that she did. I know there was a whole bunch of discussion about it, and they were. I think the original plan was to call Jane Doe's mother and Lisa Marie Presley around the same time, and I don't believe either one of those individuals were called.
Right. And if you want to talk about something that would demonstrate not just a prior consistent statement, but it also but vouching for the nitty-gritty details, and also the fact that Scientology was being obstructionist in this matter, although to some extent I'm not sure how much that doesn't really impact the guilt or not guilt in this case. I mean, honestly, right?
Sure.
But I think seeing those reports, or like if they were admissible as evidence, or are you saying even if Jane Doe 1's mother got up there and testified with a clear memory about everything she wrote in that report, are you saying the jury wouldn't get to see that report?
No, I'm saying the jury would get to see the report because it's not a police report, because police reports are hearsay. Not all reports are hearsay. There's also something called the best evidence rule, which is a little bit nuanced, but essentially it says that if there's another way to get the same information that's on a written statement, primarily by calling the witness who made the statement, if the witness is available, we have to call the witness, but that's a little bit nuanced, and even it's not something we see a ton. It's normally you have the report in your pocket, you're going to sit in the stand and talk about it. So not directly relevant. The prior consistent statement thing is it's a little bit backwards, because we actually teach it as the prior inconsistent statement, but I can use the rule to also show that the witness, in this case Jane Doe, had made this same statement one or more times prior to the time she's sitting in the chair testifying to. And we can do that either through documentary evidence, such as here is a knowledge report or things that shouldn't be, or whatever type of documentation that was submitted. Here is an affidavit that I gave here, and then here's 4 witnesses that I made these statements to, and then these 4 witnesses are going to talk about the discussion that Jane Doe and the witness had as it pertains to the facts of the case.
Right. That makes sense. Okay, here's a question from Kyle Stark. Tony Ortega says Masterson needs to be convicted of more than one count or he will walk due to California statute of limitations. Is that true?
That is absolutely true. So prior to 2017, and this is based on my research, I'm not a lawyer in California. Prior to 2017, the statute of limitations for rape was 10 years. And all of these cases occurred prior to 2017, and these types of statutes cannot be retroactive, so you can't apply them to acts in the past. They only pertain to acts going forward. So that would mean the statute of limitation in all 3 of the acts charged against Danny Maasterson have expired individually. However, California has what's called the one-strike statute, and if for the viewers who may be familiar with RICO, Racketeering, Influenced, and Corrupt Organizations Act statute, which is a federal law, it says that even if I can't prosecute a singular act of misconduct because the statute of limitations has expired, I can prosecute those individual acts together on one larger charge if there is an underlying predicate act, right? And this is how they got the mobsters, right? You can't prosecute the mob boss if he's not gangbanging on the street corner, but if he's giving orders to do bad things, we could prosecute the mob boss by getting the lower folks, right? And so it's the same sort of theory. That's kind of the theory the California one-strike statute is around. The reason this applies is that Danny Maasterson is alleged to have conducted 3 specific acts of wrongdoing, and all 3 of those acts are the same types of acts. In this case, assault-related crimes. Okay, and
so. Well, I mean, I didn't want to interrupt you if you weren't done. Did you have more you wanted to say there?
Well, and essentially, in order to win on that, if the jury has 1 guilty and 2 not guilty verdicts, ultimately Masterson will not be convicted of the ultimate charge of violating the one-strike statute, because the one-strike statute says a singular act is not enough. It has to be 2 or more. So they have to go at least 2 for 3 in order for Danny Maasterson to be facing any type of incarceration.
Right. Okay, here's a question from Fabian Andeal. I don't understand where the problem lies for David Miscavige to appear in front of the court. Like in the Masterson trial, he can always lie like every other sociopath. I think you're probably referring to the fact that Miscavige has gone so far out of his way to avoid service in some of these civil trials. It's just a matter of Miscavige, he can lie, but that's risky. It's very risky. It's one of those things where if you're telling the truth, you don't have to remember anything. If you're telling a lie, it's very hard to keep track of all the lies you've told. There's so many things that could come up in a deposition from Miscavige, not even related to the case, relating to Scientology, relating to L. Ron Hubbard, relating to Lisa McPherson, relating to Jerry Armstrong, Pat and Annie Broker. He simply feels that he cannot afford to ever allow himself to be deposed. And he has enough resource, enough money to throw at the lawyers to do everything to make that happen. So I guess you could say that in some respects, Masterson is just maybe has a little more courage than the little slimy weasel known as David Miscavige. Not that Masterson had any choice in the matter. I'm sure he would have avoided having to appear in front of anyone if he could himself, but I'm just trolling Miscavige at this point. You know, if I put myself in the victim's shoes, as much as I want to see justice, would want to see Danny brought to justice, man, it would be hard for me to stomach having to go through all of that testimony again. I imagine they would still rather do it than not do it, but that's a tough pill to swallow.
Yeah, it's interesting too, because the charges have already been filed, and a judge of competent jurisdiction, Judge Almeida or somebody else in the criminal court building, has determined there's enough evidence for it to go to trial. So even if there's a mistrial, The charges still stand. If there's a mistrial, the prosecutor has to do one of two things: dismiss the charges or prosecute the charges. It can't just sit there forever and just be in limbo for existence. The charges are filed. A mistrial does not make the charges go away. It just resets it back to basically the pretrial conference, which is the last hearing before trial starts. But that also means that all of the prior decisions on motions in limine, all the prior orders on the limitation of what role, if any, Scientology can play, the other prior rulings as it pertains to Lisa Marie Presley's testimony, all of those other prior rulings no longer apply, because those apply to the trial that they're deliberating now. If there's a retrial, there will be a significant motion practice prior to that, because the judge will have to make, the state will again seek, and the defense will seek to exclude copious amounts of Scientology. The defense doesn't want any, and the state wants as much as they can, and the judge limited it. All these things Judge Almeida has already decided. They're going to have to, they will be rebriefed and there'll be motions filed, and the judge will have to issue new orders.
Fascinating. Well, that you almost directly answered the question I was going to ask before, which is, it took years for this case to come to trial, even after the charges were filed. And I wondered to what extent we would reset the clock completely, or would it be a faster path?
It'd be a faster, I mean, theoretically, like in federal, I'm going to use a federal court example. In federal court, once the government brings charges against the defendant, the government has to be prepared to start trial in 77 days. Unless the defendant waives speedy trial, it's 77 days. I could easily see, depending on the court's docket and availability, if let's assume that the judge had ordered a mistrial yesterday, this could easily be ready for trial by January 1st.
Oh,
I don't know.
Fascinating.
I don't know if the court is capable of having the case, of having her docket ready in time, but also because of the nature of this case, there's going to be thousands more summons issued for jury service. So the holdup would be the administrative part, not the actual lawyering part.
So if this gets retried, if it does indeed end up in a mistrial, you're saying that the trial would occur again in months, not years.
Right. Yes. If the court could get summons issued, if they could get a jury pool selected to show up for jury selection, as long as they could get all of the administrative parts of the trial done, which the lawyers don't really have much say in anyway. The holdup would be, how quickly can we summon jurors? Most jury summons go out about 6 weeks in advance. So they can tell employers, they can cancel vacation plans, they can do all these other things. So, you're probably looking 12 to 14 weeks, but assuming there's room on the docket. And what, at least in my state, in Oklahoma and in Colorado, and the two states I practice as well, the federal courts, every case has a case number. The lowest case number is the oldest case number. Oldest cases get tried first. So if there's another trial in the way and the Masterson trial is ready to retry, they will move that trial that's set later and slide that Masterson case in here and try it.
Oh, very interesting. Here's a question. I like this one. Was the jury instructed about the 3 strikes rule? Do they know they need to convict on at least 2 counts? What are your thoughts on that?
So I don't actually know what the jury instructions read. The lawyer in me, having knowing the philosophy and the concept behind the way these laws are written, I would assume, based on no knowledge of having read anything, I would assume that they're not actually informed that they need 2 of 3. Because 2 of 3 could affect the jury's determination. Like, listen, we think he did it. We certainly believe Jane Doe X. We sort of believe Jane Doe Y. We don't at all believe Jane Doe Z. And I'm using letters because I don't want to remotely make any implications as to believability of the actual victims. But we love the testimony of this one. We like the testimony of this one. We're going to eliminate this one. If they know they have to go 2 for 3, they may say, you know what, that's a compromise verdict. We can get to 2 for 3. As opposed to, they need the law is set up so that the jury has to make individual findings of fact as to each allegation about each victim by Danny Maasterson. Charge 1, charge 2, charge 3. They should not be influenced by the necessity of having to have an X number of convictions for this to stick.
Yeah. So that question reminds me of, I remember I had a similar question when the Amber Heard Johnny Depp trial was concluding. And I remember, and I'm going to forget the words, because there was 2 sort of financial findings. One was the punitive, but what comes before the punitive?
Actual damages or compensatory damages.
Damages and punitive. And I remember seeing that the jury found, X for damages and then a lot more for punitive. And you sort of got the impression that the jury wouldn't have bothered in coming to this large punitive number if they knew it was going to be capped at like 600,000 or whatever it was capped at. It was capped at some very low number.
Exactly.
And you'd think if they knew that in advance, they might have massaged their numbers to put it all in damages.
That's absolutely correct. So the compensatory damages are actual damages. That is, here's what it takes to make you whole. Your career, let's say Johnny Depp's a movie star. These allegations cost you $10 million in income for movies you couldn't make because they wouldn't hire you to be in the movie. That makes him whole from what he lost out on. The punitive damages are designed to punish Amber Heard for that wrong. The thing you did was so bad, nobody should ever do it. We're going to punish you. If the jury knew there was a cap, they would increase the compensatory damages. So now Johnny Depp is actually being paid more than what he is entitled to be made whole. So we keep that secret from the jury, let them award their damages, and the court will come back after the fact and make reductions in those awards in compliance with the law.
Right. So that same theory, you almost wouldn't want the jury to know that, hey, he doesn't go to prison unless you find him guilty on 2, because then a juror who wants to see him go to prison will be like, oh, well, then now I'm automatic. Like it would affect the jury.
Right. Or it could also be that, let's say you've got a juror, all the jurors agree with the story of Jane Doe, whoever, he absolutely did that thing to Jane Doe. All the jurors agree that one of the Jane Does, not believable at all, he absolutely didn't do that thing to this Jane Doe. The one in the middle is the key. And if the jury knows, I've got to get 2 out of 3, there may be that one juror who says, I don't really think he did this thing to the third Jane Doe or to the ex-Jane Doe. However, I really want him to go to prison, so I'm going to find him guilty anyway.
Right. That makes sense. I mean, that makes sense. I get that. Let me see. I know there was another question that I mean, this just comes out of what I would like to personally see happen. It's very easy to be an armchair prosecutor, but if you're the prosecutor over there, you would be thinking, what could I do differently next time to really drive it home to the jurors, even maybe from a more emotional standpoint instead of a factual standpoint. I mean, I think you put Lisa Marie Presley on the stand. I think you put Julian Schwartz on the stand. I think you put some of these guys on the stand who might lie for Scientology and might plead the fifth. But, I think, I'll speak from my experience. You might be able to tell a juror that there's nothing wrong with pleading the fifth. There's nothing wrong with this. Mm-hmm. Jurors still think there's something wrong with pleading the fifth.
I would agree with you, even though every appellate court, to my knowledge, including the U.S. Supreme Court, has said the corrective admonition by the judge, ladies and gentlemen, the witness took the Fifth Amendment. You're not to hold that against him or her. They absolutely do. But the problem is there's no way to prove it. How do you prove the absence of something? Right?
Right. And that's why I'm saying I would like to see it happen, but that doesn't mean a prosecutor would do it. Okay. So I did not realize that if there's a mistrial, everything got the charges don't go away. Like you said, you now have to dismiss the charges or retry. You have to do one or the other. I think a prosecutor would have a very tough time describing how they would just dismiss the charges in this case. Is the fact that you don't think you can win find enough reason to dismiss the charges?
Yeah. So you can a prosecutor could dismiss charges for any reason. I mean, it's literally a 2-sentence filing. The state comes the state by Attorney Cohen or Attorney Mueller rather, and hereby dismisses the complaints and the charges against defendant Danny Maasterson, signed and submitted, and the charges go away. It's 1 or 2 sentences.
I got it. Somebody might use it against him if he runs for reelection when he's running for reelection. But other than that,
yeah, absolutely. And that's the problem. Once somebody's charged, you've either got a prosecutor or not. Now, the backside of the argument, I didn't say this earlier when you asked, what are the benefits to who's got the advantage, the prosecution or the defense on the retrial? Once the data comes down on what the jury deadlock count was, let's say it's 10-2 or 11-1 to convict. That may be reason for Danny Maasterson to try and find a plea agreement with the prosecutor. Right? We almost got you. We just missed, but we're going to put another jury in the box and we're going to refine our testimony. We're going to refine our technique, and then we're coming at you.
Oh, that's a great point. That is a great point. And that you just reminded me of what is probably my last question. So once the jury comes out with their actual results, we're going to find out what the split is. Do we or the lawyers or the judge ever find out what the split is before they're ready to make a final decision?
No.
Okay.
In fact, the jury probably has an instruction that says, you know, when you have an issue, the only person that signs the question is the foreperson. In fact, the lawyers and the judge shouldn't even know the names or the juror numbers, the juror identities of those who are voting those who want to convict, those who want to acquit, and those who haven't decided. Because if we look at that and we go, oh, all the men voted to acquit, but all the women voted to convict, well, in this very small vacuum or data set in a vacuum, let's put 12 women on the jury. If I'm the prosecutor, I want 12 men if I'm the defense attorney. Right. And so that the demographics of the jurors also probably, I would be very surprised if the demographics or the identities of who's voting yes and who's voting no ever come to light. There'll be a form go back. Write down on this box the number of jurors who wish to convict. Put in this other box the number of jurors who wish to acquit. Sign to the foreperson. Return it to the judge. Oh, it's 10-2. Oh, it's 11-1. Oh, it's 6-6.
Oh, so they only poll the jury when it's unanimous?
So the polling of the jury is after a verdict is reached. And in a criminal case, it has to be 12-0 to convict or 12-0 not guilty. In the Johnny Depp trial, in the Alex Jones trial, the civil trials, it can be like in Oklahoma, I don't even have to have 12 jurors. If I have 12, I have to have 7 vote. I have to have 7 people agree with the verdict. I could go 7-5 and win. If I have 6 jurors, I have to go 6-0. If I have 8 jurors, I have to go a minimum of 7.
So if the jury says we can't reach a verdict, a mistrial is declared, we will find out the number split. We will not find out which jurors voted which way.
Yes, we should. It is possible, and I don't have any reason to believe that this would be the case. It is possible that the judge would make available to the lawyers a copy of the form that has the numbers, file it in the court record, and then seal it. File it under seal. So again, higher profile cases to keep the reporters from going, oh, look, we had 11-2, we had 7. And so now you've got the reporters and the media and then a whole nother jury pool coming that we have to select from. Like there's some logistical issues that, although I have no independent knowledge that this could happen, I would not be surprised, although I don't expect it to happen. I wouldn't be surprised if at some point the judge decides to seal that until the ultimate trial is tried and a verdict reached.
That makes a lot of sense. You know, whenever I hear of things being filed under seal, I sort of roll my eyes and is like, does that really matter? Do sealed records get leaked? I mean, you had the thing from the Supreme Court get leaked earlier or last year or whatever it was. How protected are those things?
Well, they're sealed. When I say sealed, they're literally put in an envelope sealed, and then the seal of the envelope is signed by the court clerk. So that if the public walks up to the record, the court clerk hands the paper file over, they remove those records that are sealed. And so to open something under seal takes an order from a judge. This is to be opened by the court clerk. Right. And so when I say sealed, I mean, I've never known it to leak. And now as a lawyer in the case, I will have a copy of that sealed order. Oh. But that's protected attorney-client information. That's protected case file material. I don't have to disclose that. I have to disclose that I have a copy of a sealed order, but I cannot disclose the contents of the sealed order. In my knowledge, I've never known of other than the Supreme Court thing, and people got fired for that, by the way. In the event of the Supreme Court thing, I've never known of a sealed order to be leaked. And if it could be proven that a lawyer was involved in that leak, that lawyer would be disbarred. They would immediately be suspended from practice by the governing authority and very likely disbarred. That's how big a deal it is.
Yeah, I was just going to say, so that means a sealed order could leak from an attorney's office, not from the court itself, but it's up to the attorney has an incentive to make sure that does not happen.
Absolutely. Because here's the deal. I mean, now it does get a little bit down in the weeds, First Amendment thing. Generally speaking, press are protected in their sources. So if the New York Times were to run a copy of the sealed order or were to have access to one and were to summarize it, and then the New York Times author or the writer who wrote the byline, who wrote that, were to get subpoenaed, in most jurisdictions, they could say, I don't have to reveal my sources and they can't be compelled. And that's sort of the honor system among lawyers, because if I leak this, I'm putting not just my reputation at risk, but my law license at risk, because because the journalistic public can say, we don't have to snitch on our sources.
Right. I know that's protected under the Constitution, but that kind of stuff makes me deeply uncomfortable.
You're not the only one.
All right. Well, that's all the questions that I have about this. Anything else you think we should discuss about it?
Yeah, I don't think so. You've got some really good fans, and I've been seeing a lot of the love that your fans give to you and the love they give to me. And so, for those of you who are out there, I do very much appreciate those kind words. I try if I see a question that I can quickly answer in the comments, a couple of words, a couple of sentences, I try to answer those when I can. So if you did ask a really specific question, you didn't get an answer, I promise I read it, but it's really a question that needs it's a dedicated conversation and not just 2 or 3 sentences. So I do see your questions out there. I answer them as I can, and I do appreciate all the kind words that you guys have.
Awesome. And hey, Zach, if you ever start a YouTube channel of any kind, I'll certainly help you promote it.
Well, I do appreciate it. In fact, we're working on standing one up. We're hoping maybe shortly after the first of the year. And I was telling my future co-host about you. He's a bit of an agnostic, a secular humanist, was raised Catholic and then sort of disaffiliated with organized religion. And I said, hey, there's a guy you need to talk to. There's a guy that I do some contributing for in Florida. I think the two of you get along. We need to have a conversation. So once we get that up and running, you'll probably get a message from me. We'll see if we can have you on.
Absolutely. All right, everyone. Thank you for tuning in, and we'll talk to you soon.